Hello, this is Attorney Brian Pendergraft, and this is the law on failure to pay rent in Maryland. And what you see before you is Maryland Real Property Code Section 8-401, and that is the actual law on failure to pay rent in Maryland. That said, I gotta throw out a few disclaimers here. This is legal information. This is not legal advice. And this is also, I like to throw out, this is just one attorney's interpretation of this statute here. And if you would like to follow along, I have the link to this law in the description. That said, when you pull it up, your version is not going to be color coded and highlighted like mine. Everything's just going to be white. I kind of highlighted the parts that I thought were important. And I'm just going to try to run through this try to run through this kind of quickly, and I'm going to try to highlight the parts that I think are important. I don't necessarily want to read it verbatim. I want this to move kind of quick. But I want to be thorough at the same time too. So let's try. Let's see how this goes. All right. So 8-401 Section A. So it states that whenever a tenant fails to pay the rent when due and payable, shall be lawful for landlords to have again and repossess the premises. So that is what gives landlords their cause of action to that is what gives landlords the cause of action to file for failure to pay rent and to attempt to gain possession of the property. That's all Section A is saying. So Section B. Whenever any landlord shall desire to repossess any premises to which the landlord is entitled under the provisions of subsection A of this section, the landlord or the landlord's duly qualified agent or attorney shall file the landlord's written complaint under oath or affirmation in the district court of the county wherein the property situation, where the property is situated. Excuse me. All right. Translation. So what that is saying is that a landlord can file a written complaint in order to gain possession of the property, and it states the venue. So one, the complaint must be in writing, and two, it states the venue, and the venue is the district court of where the county is located. So I practice primarily in Prince George's County, so that means we have to go file generally in Hinesville District Court. If you're in Montgomery County, you have to go file in Rockville District Court. That is the district court, not circuit court, not Orphan's Court, any other court, district court. All right. Moving on. I'm not going to read this entire part here that I have highlighted in orange, but this orange section here, this states what this does is it lays out the terms of a failure to pay rent complaint. So as long as you fill in all of the here's a failure to pay rent complaint right here. So as long as you fill in all of the blanks, then you will comply with with all this stuff here that I have highlighted in orange. Now the issue is that what I should point out is that essentially this requires that let's see, hold on, let's see which part should I point out here. Let's see, lead certificates, inspection certificates. Right. So inspection certificate number. Let's see. I like this here. I'll focus on this. So we're looking at B. So after February 24, 2016, stating the inspection certificate number for the inspection conducted for the current tenancy as required. So essentially, what this is saying, if I can do sort of Cliff Notes version, is that your property, if it's required to have a lead inspection certificates, in other words, if it was built after built prior to 1978, you may be required to have a lead inspection certificate. In which case, you better have your inspection certificate number or an exemption number, and it needs to be filled in. And similarly, if a landlord is required to have a rental license, let's say if you're required to have one of them in, I'm going to say Prince George's County, Montgomery County, Baltimore City, I think in some places in Baltimore County, you're required to have a license. You need to have your license filled in, because if you do not have a license, you do not have an inspection certificate number, your complaint will be thrown out. All right, so moving on to this green section here. So this states that let's see. So this district court shall issue a summons directed to any constable or sheriff of the county entitled to serve process, and ordering the constable or sheriff to notify the tenant, sign your subtenant by first class mail. So after you file your complaint, what this is saying is that a summons is going to be issued to the sheriff or constable for them to serve the complaint. So that is how the tenant gets notice of the property. Moving on to this purple section here, if personal service is requested and any of the persons whom the sheriff shall serve is found on property, the sheriff shall serve any such persons. And if they can go further on, if personal service is requested, none of the persons whom the sheriff is directed to serve shall be found on the property. In all cases, person service not requested, the constable of the sheriff shall affix and assess a copy of the summons conspicuously upon the property. So they will try to serve them by so they'll try to serve them. Now, it does say that they will try to serve them by personal service. Now, again, where I practice, that's not what they do. They just affix it to the door. They don't actually try to personally serve the person at all. Fortunately, as you can see, this blue section here, the fixing of the summons upon the property shall after due notification to the tenant, assignee or subtenant by first class mail, shall conclusively be presumed to be sufficient service to all persons to support the entry of a default judgment for possession of the premise, together with costs in favor of the landlord, but it shall not be sufficient service to support a default judgment in favor of the landlord for the amount of rent due. Translation. So generally, when you go to landlord-tenant court, you're just going to be able to get the possession of the property, generally speaking. So you can get possession of the property, but and in order for you to try to get, let's say, a monetary judgment, because that's what landlords always want, right? They want their money back. But in order for you to get a monetary judgment, typically what landlords do or need to do is they have to file another lawsuit in contract or tort in regular civil court. So landlord-tenant court tends to handle possession. Now, there is a way to get, your rent, but to get your rent, and even in landlord-tenant court, and I'm going to discuss that a little bit further down. Is red section here. This is I'm going to skip this because I don't practice in Wicomico County, but Wicomico County has some weird rules. So if you are in Wicomico County, you can, take a look at that. All right. So moving on to this purple section here. So, notwithstanding the provisions of paragraph 3 and 3 subject, the landlord serves in court and written complaint under paragraph 1 is subject to the best of the landlord's knowledge. The tenant is deceased and tested. All right, cool. So this is stating that what happens if your tenant is deceased, essentially. So you can still file for failure to pay rent and try to get possession of the property back, essentially. But again, you're probably bless me. You're probably not going to get a monetary judgment, but you can at least get possession of the property back in tenant's deceased. And on the form, they actually have, this is actually reflected on the form, number 10, if the tenant is deceased without next of kin, you just want to make sure you check that box off on the form. Let's see, moving on further down. Let's see, what is this green section here? Why did I highlight this? Oh, okay. All right. So this is I remember why I highlighted this now. Subsection applies only to an eviction for the possession of residential property for failure to pay rent due during a government shutdown. So if your tenant is an employee of a local government and or they are a state employee and they are let's say they are a victim of let's say there is a government shutdown, then they have a right to ask for a stay. So again, I guess the intent of this rule is so that we're not evicting people that that would otherwise pay their rent had it not been for a government shutdown. So that's something to keep in mind. All right, so moving further down. Why do I have this section in orange here? Let's see. When the trial occurs, besides the court, rent, a part of rent, late fees are actually due and paid. The court shall determine the amount of rent and late fees due on the date the complaint was filed, less the amount of any utility bills, fees, security deposit by a tenant under 7-3 is a reminder of the public to this article. If the trial occurs at the time specified by subsection B3 of this section. Translation. So that just says that the court can determine how much rent and late fees are due. All right, got it. Let's see. Moving further down. Again, this is this is the court determining how the rent and late fees are due. Let's see. Rent, late fees are due. So they can determine that essentially, They have to determine, but they stick to what's in your complaint. You can't go any higher than what you list in your complaint. So that's the important thing to note there. So if you're suing, so if someone owes you $1,000,000 and you only write in, I don't know, $10,000, the court, they can only grant you $10,000. So that's the important thing to know about there. And Section D here, I think this is pretty important here. Credit for payments of rent, late fees, and other fees, utility bills, and security deposits paid by the tenant under Section 7-309 of the Public Citizens article after the complaint was filed, essentially. So what that says is that the tenant will essentially be credited for the payments and for any payments that they did make. So that will be used to adjust whatever amount that the tenant owes. All right, so this is what I was saying earlier about personal service. So in the case of resident tenancy, the court may also give judgment in favor of the landlord for the amount of rent and late fees determined to be due to cover the cost of the suit if the court finds that the resident tenant was personally served with a summons. So again, if you want to try to get that money or get a money judgment, you need for the tenants to be personally served. And you want to hire a process server to do that. So in the case of a non-residential tenancy, if the court finds that such service, a process, or submission to the jurisdiction of the court would support a judgment in contract or tort, the court may also give judgment in favor of the landlord for the amount of rent and late fees determined to be due, cost of the suit, reasonable attorney's fees, if the lease agreement authorizes the landlord to recover attorney's fees. So in other words, this for commercial tenancies, landlords are able to, even with, I guess, regular sheriff service, they are, or with sufficient service, they are able to ask for rent, late fees, and their attorney's fees amount. All right, so moving down, section that I have here in red, I found this pretty interesting. So if they have a certificate if a tenant has a certificate of a physician and they have been ordered to leave, they can extend the time to surrender the property, but not more than 15 days after the trial. But I guess, but even if, I actually wonder how practical that is actually, because the sheriffs generally don't get there 15 days after the trial anyway. I mean, whatever county's got sheriffs going out, getting there within 15 days is that's amazing. I'm telling you what, that's not happening in Prince George's County. You're lucky to get it tendered out in 30 days. All right, so moving on. All right, so this is however the tenant or someone for as orange section here. So however, if the tenant or someone for the tenant at the trial or adjournment of the trial to the landlord the rent and late fees determined by the court to be due and unpaid together with the cost of the suit, the complaint against the tenant shall be entered as satisfied. In other words, the tenant that is tenant's right of redemption. They can pay and stay. So as long as they pay, they can stay. I mean, assuming that I'll get to it a little bit further down actually. So moving on to this purple section here. What is going on? The judgment is given in favor of the landlord and the tenant. So this is fails to comply with the requirements of the order within 4 days. The court shall, at any time after the expiration of 4 days, issue its warrant directed to an official of the county entitled to serve process, ordering the official to cause the landlord to have again repossessed property by putting the landlord or the landlord's duly qualified agent or attorney for the landlord's benefit in possession thereof, and for that purpose to remove the property by force, if necessary, all the furniture, implements, tools, goods, effects, and other chattels of every description whatsoever belonging to the tenant or to any person claiming or holding by or under said tenant. Translation. So that's what gives the landlord can file a warrant for restitution, and the judge can order the sheriff to go to the place. You can bring you're gonna have to hire and bring an eviction crew, by the way, because the sheriffs are not moving anything. They're just there to make sure that nothing bad goes down. So your eviction crew can throw out the person and their things and any other person holding under right of said tenant. All right, so moving further down. If the landlord does not order warrant for restitution within 60 days from the date of judgment or from the expiration date of stay of execution, whichever shall be later, the judgment for possession shall be stricken. So, in other words, make sure you file your warrant for restitution within 60 days. All right, moving further down, administrative judge of the district, this is the other section that I have in orange. The administrative judge for any district may stay the execution of a warrant for restitution of a resident property from day to day in the event of extreme weather conditions. So, I found that interesting. So, as long as there are, extreme weather conditions, they can delay an eviction. So now you know. What actually tends to happen is that the sheriff will, at least in my experience, what happens if there's extreme weather and there's and an eviction has been scheduled, what usually happens is the sheriff they'll just call me and tell me that, yeah, this eviction is not happening today. It's raining outside. So that's what generally happens. All right, so moving on to this purple section here. To the paragraph 2. Subject to paragraph 2 is the subsection to any action of summary ejectment for failure to pay rent, where the landlord is awarded judgment giving the landlord restitution of the lease premises. The tenant shall have the right to redemption of the lease premises, tendering in cash, certified check, or money order to the landlord's agent, and all past due amounts as determined by the court under subsection C of this section, plus all court costs and fees at any time before actual execution of the eviction order. So tenants can pay and stay, but this subsection does not apply to any subtenant against whom 3 judgments of possession have been entered for rent due and unpaid in the 12 months prior to initiating the action to which the subsection otherwise would apply. So if there are 3 judgments of possession entered in the last 12 months, and it's like, and then you get another judgment against them, they do not have the right to pay and stay. And they do not have the right to pay and stay. They lose their right of redemption. Last section here that I've highlighted: tenant or landlord may appeal from the judgment of the district court to the circuit court for any county at any time within 4 days from the rendition of this judgment. And translation: there is a 4-day appeal period. And here is the last section here, which is not highlighted. The tenants must pay a bond. So that is it. That is the law on failure to pay rent in Maryland. I hope you have found this helpful. Hope you found it useful. You need to contact me, or I need to turn to help you out. My stuff is all in the description. Alrighty. Thanks for watching.